I'll call the meeting to order. Standing Committee on Access to Information, Privacy and Ethics. Meeting number 84, pursuant to Standing Orders 111.1, Certificate of Nomination of Mario Dion to the position of Conflict of Interest and Ethics Commissioner, referred to the committee on Monday, December 11th, 2017. I'd like to welcome you today, Mr. Dion, and you have 10 minutes. Thank you.
Much. Mr. Chairperson, members of the committee, I am truly honored to appear before you this afternoon to discuss my nomination as the next and second Conflict of Interest and Ethics Commissioner. I sincerely hope that we have, after we've had a chance to discuss my credentials and my plans, that my nomination will be approved by the House of Commons. As you know, this office was established some 10 years ago as an independent officer of the House of Commons to provide assistance to appointed and elected officials in ensuring that conflicts between their private interests and their public duties are prevented. This was deemed necessary by Parliament to maintain and to further enhance the confidence of Canadians in the House of Commons and its members, as well as public office holders. Le commissaire à l'éthique et au conflit d'intérêts.
The Conflict of Interest and Ethics Commissioner administers two texts: the Conflict of Interest Code for members of the House of Commons and the Conflict of Interest Act. The code, adopted in 2004 and amended thereafter a number of times, applies to 338 MPs. The Act manages the behaviour of public office holders of today and of the past: ministers, state ministers, parliamentary secretaries, members of staff, ministerial councillors and advisers, and those who are appointed by the Governor and Council. In its last annual report, Commissioner Dawson stated that there were 2,254 such people on the 31st of March. This office's role is, first of all, a preventative one. The Commissioner has the powers to investigate if a code or act violation has been allocated, which has been the case since she was appointed in 2007.
The main responsibilities of the office are to provide advice to individuals whose conduct is governed by the code or by the act, to review the confidential reports that they are required to submit, and to establish compliance measures, to maintain a public registry and confidential files, and to administer a penalty regime under the act. I understand that you've had an opportunity to consult my curriculum vitae. As you know, I am currently chairperson of the Immigration and Refugee Board. I have played a number of roles in the public sector since joining it as a legal advisor. I am originally from Montreal, but I am not un avocat de Montréal. J'ai quitté Montréal en 1973.
I left Montreal in 1973, and I've been in Ottawa since then.
My family moved to the National Capital Region shortly before I entered law school at the University of Ottawa. I am married and the father of 3 adults now in their 30s. I chose the public sector originally because I wanted to contribute to issues that matter to society as a whole, as opposed to purely personal and private interests. I've always been intellectually curious, and I also wanted to ensure that I would not be restricted to the same duties for the whole duration of my career. I have been privileged to be able to work in areas that are important to Canadians, but also correspond to my personal strengths as a jurist and as a leader of professionals in the public sector. I spent a total of 18 years at the Department of Justice in several senior positions, including that of Associate Deputy Minister, and 4 years as Assistant Deputy Minister with the Correctional Service of Canada. I have been a Deputy Ed since 2003. I've been an agent of Parliament for 4 years as Commissioner of Public Sector Integrity between 2011 and 2014, as well as head of 2 independent tribunals, the Parole Board and now the Immigration and Refugee Board. My most important achievement is without any doubt the finalization of the Indian Residential Schools Settlement Agreement in 2005, while I was the Deputy Head responsible for the resolution of issues arising out of this terrible chapter of our history. Je suis donc un fonctionnaire de carrière, fier d'avoir servi.
I'm therefore a career public servant, proud to have served Canada and my fellow Canadians. We have that in common as MPs, senators, and public servants.
Dawson's term was coming to an end about a year ago. I did not apply, as I had a number of objectives to finalize at the IRB. I only decided to apply late this summer, after having finalized an action plan to face an almost unprecedented increase in the number of refugee claims being made at this point in time. So we've developed a very organized action plan to try to maximize the use of our resources and to increase the number of claims that we're able to deal with. And we have increased by 25% the number of claims compared to last year, with very few additional injection of resources. And I also wanted to recruit a few key senior managers at the IRB before thinking about going anywhere else. Le 18 août, lorsque je me suis assis à mon...
And then I sat at my PC on a Saturday or on a Sunday. I decided that it was time to apply for the position.
Though there wasn't a deadline per se, but they were saying that they would start to review candidacies on July 28th, but they said, you know, if you wish to apply, you nevertheless can do so afterwards on the poster itself. So I applied. I had a call in mid-November, basically, to invite me to an interview, and I was interviewed less than 3 weeks ago, and here I am today. Je pense posséder les attributs nécessaires pour...
I think that I have the necessary attributes to meet the requirements of this position that is very important for our democracy. I believed I've led professional organizations at the federal government for 30 years, legal experts and also people who work in economic and social sciences. I have a reputation as a good leader of professionals. I take great pleasure in leading teams, in planning the implementation of results. I like working on concrete matters, important matters, and I also love being autonomous whilst being accountable, of course. For over 10 years, I was a delegate for the Deputy Justice Minister, John Pate, who was the first Deputy Minister who had delegated that mission to me. The following two Deputy Ministers gave me the portfolio of conflict of interest in the department, and I made hundreds of decisions with regards to outside activity requests, publishing treaties or articles. I had to work with codes that had constantly changed since 1992 and 2003 with regards to investigations. I have an experience when I was Commissioner for Public Sector Integrity. We organized about 100 investigations. Usually this involved senior public servants and often happened in a difficult climate, a climate when one is being studied, one isn't necessarily happy about it. And so the situation was very difficult, investigations that had to be done with discernment and tact. Now, with regards to education, there is a pillar of education that is necessary because people are targeted by the code and the act. But we also need to raise awareness with the public. I have raised a lot of awareness in the public service and at the Department of Justice. I organized sessions that raise awareness and that make people understand often complex matters. I try to make difficult things easy to understand whilst preserving the precision of the systems that I was explaining.
This is essentially why I believe I'm qualified for this position. I would really like to make a direct contribution as Canada's second Ethics Commissioner, and I hope that I will enjoy your confidence to do so. Although it's always difficult to make statements about one's priorities when you're not fully informed, as you know, everything that Ms. Dawson's office does is confidential, so I don't actually know much. All I know is what I can see on the web and what I can read in the media. So it's hard for me to launch a very informed description of what my priorities would be. But based on what I've read, I did allude earlier to the education aspect. I think it's very important. The code and the act are very complex in my view. And Mary Dawson said the same thing last year or 3 years ago when she appeared before this committee. They are complex. Therefore, it's hard to imagine that every public office holder and every is able to essentially, within a few hours, grasp precisely what is expected of her or him. And I would like to do more education to try to disseminate the information as well as possible. I believe that people are fundamentally honest, that people do not get up in the morning with an intent to breach the law, and therefore it's important to make sure that they actually understand what the expectations are. So I would like to do more of that. I would also, one of the things I've done in several positions I've occupied is always a focus on trying to increase efficiency, to optimize the use of resources that the government makes available to us wherever I have been. So not knowing much about the current operations, I sense that maybe there is more room for an increased use of technology potentially that I would be looking at. So, Mr. Chairperson, I would once again thank you for inviting me to meet with the committee this afternoon. I will be pleased to answer any question that members may have of me. Thank you very much.
Thank you, Mr. Dion. It sounds like a good place to start, trust and efficiency. So we'll start off with Mr. Saini. 7 minutes.
Good afternoon, Mr. Dion. Thank you very much for coming here this afternoon. We want to assure you that we will greet you very warmly here, and we appreciate the 3 decades of service that you have given to this country. I think that's a phenomenal achievement. You spoke a little bit about education. I think the context you were speaking of was your own education in terms of the Conflict and Interest Office. My question to you is that there may be some Canadians who may not understand the role of the office, and they may not understand the responsibilities, and they may hear it once in a while in the media. But my question to you is: do you think that it's important for Canadians to understand, and what do you see as your role in educating Canadians going forward?
I think it's important that Canadians understand that there are a number of mechanisms, institutions, which exist to continue to improve. We are already seen as a model of democracy, a model of integrity as well. Canada is already very well positioned, but the average Canadian probably does not appreciate fully the institutions that do exist in addition to this office, to ensure that this remains so and it continues to, there is a solid foundation essentially, to ensure that we continue to be solid and to further increase the probity, the integrity of our elected officials. So I would like to, albeit everything in particular that the office deals with is confidential, I've had a media presence in previous positions. To the extent that it would be possible and compatible with the duties of this position, I have a natural tendency I like doing media, unlike several of my former colleagues. But this position has clear limitations, of course. This is not first and foremost a public relations position, but to the extent possible, I would like to use the media as well to try to increase the understanding of the position, its role in maintaining integrity within government, within the legislative branch, and so I would be looking at that.
I want to ask you, in comparison to your current role as the chairperson of the Immigration and Refugee Board of Canada, the decisions that you make on a daily basis have a huge impact on people's lives. And in this new role, you would be carrying a similar weight. You would be making decisions on people's careers, their reputations, and potentially their lives. How has your experience as chairperson of the board prepared you or will be helping guide decisions in this new role?
I think decision-making is a discipline. It comes with the ability to analyze facts in an impartial manner, in an objective manner. It is transportable from one area to another. As chairperson of the IRB, I do not actually make decisions involving refugees and immigrants, but I'm responsible to oversee, to ensure that we have the tools so that our members, we have had 250 members who make decisions, who are appointed by the Governor and Council or are public servants, depending on which division they work in. And my job is to make sure that they have the tools to be in a position to make objective decisions, to make reasonable decisions, and so on and so forth. So I have experience in crafting guidelines and interpretation guides and jurisprudential guidelines, which I would. But in this instance, the Ethics Commissioner, if I'm appointed, the Ethics Commissioner actually makes all the decisions. That's a marked difference with what I'm doing now, but it's identical to what I was doing as Public Sector Integrity Commissioner, making all decisions myself.
Now, after 3 decades in public service, I'm sure running very, very different departments, you've had a vast amount of experience, lessons learned. What lessons have you learned? If you could give us maybe some examples of how you would bring those lessons of what you've learned to this new role.
I speak often about the Pareto law. I don't know if you've ever heard about the Pareto law, which essentially he was a mathematician, And one of the theories is that in order to accomplish a certain objective, you basically have to, you invest 80%, you invest 20% of the time in order to accomplish 80% of the objective. The last 20% takes a lot of energy and effort. So perfection, the best is the enemy of the good. That's what I've learned. So yeah, it has to be commensurate to the importance of the issue. Everything cannot always be perfect. In our society, timeliness is also a very important reality. So trying to classify, I've done that in several positions, to classify what is important, what is slightly less important, to have a system and an approach which actually reflects the importance of what is at stake. Not to treat every matter in an identical way, because every matter is not equally important. And people should not have to wait several years in order to know the outcome when they make a complaint or when they apply for something, or irrespective of what it is in government. So often we are very risk adverse in the public sector, and this creates inefficiencies. That's one lesson. Another lesson is in a society where we have knowledge workers, people really appreciate being given the trust and confidence by their superiors, that they know what they're doing, that they are given the tools to do the work, that there is oversight, but they really appreciate not being micromanaged. That's a second lesson. I have several little lessons like that, but I think it would be inappropriate this afternoon to go on further.
So just my final question is, you talked about efficiency and how important efficiency is to you. And I know that with this new role, you may not be up to speed at exactly how the office works. As you said, you had to read about it in the media. But as an overview, there must be some things that you must know already that you find would be compelling, or something that you would find that you would like to take a leadership role on, or something that some aspect of the office generally where you feel that efficiencies could be improved. Can you maybe comment on that?
As soon as I am appointed, if I am appointed, I'll be speaking with Mary Dawson. She was a colleague of mine for several years, by the way. I know Mary Dawson very well. And as soon as I am appointed, if I am, I'll be talking to her. I have the organizational chart. It's a small office. It has 48 individuals working in it at this point in time. So that's much smaller than the Department of Justice, where we had 5,000 people when I was there. It seems to be well organized. I know Ms. Dawson is a very well organized person, but I would have a discussion with her to see how we can improve. I've mentioned timeliness is one dimension. Another dimension is communications in a way that reflects the times, basically. So not necessarily always by way of a letter. That would be another possible approach. Again, depending on the importance of the matter. Sometimes you have to adapt the mode of communication to the importance of the matter as well.
Thank you very much.
Next up for 7 minutes, Mr. Kent.
Thank you very much, Chair, and thank you very much, Mr. Dion, for being able to appear before us on such short notice. And by your application, I'm sure that you anticipate a very busy time in this office, certainly based on the performance of this Liberal government in the past couple of years. One might expect much to investigate. We're told that Commissioner Dawson is working diligently on a couple of very important investigations that the House is concerned about, two involving the Prime Minister, the most recent involving the Finance Minister. But I'm concerned by the word from her official spokesperson that there is nothing to compel her successor to complete investigations still underway or incomplete at the time of the transfer of authority. So I'm wondering if this committee could ask you to assure us that you will in fact complete those investigations which are or may be incomplete at the time of your taking office.
What I'm able to assure you of is that it would, of course, be among the top priorities. I did discuss the issue of prioritization a few minutes ago. So, of course, it would be one of the first things I would attempt to review, the whole genesis of those investigations that you're mentioning, to, if they're not completed prior to my appointment, the entering into effect of my appointment. And my job, I think my responsibility would be to ensure, because I would own the final result, and therefore I have to assess what has been done to date to determine whether I am supportive of that. But abandoning an investigation completely without reasons is not something I would do. I don't think it would be appropriate by way of a process. I have to do my own analysis. I have to make a decision as to whether anything needs to be redone, whether there is anything incomplete, but I will work on those pending investigations, of course.
Now, you mentioned part of your learning process informed by media coverage, and I'm sure you're aware that we in the official opposition are very concerned about the lack of meaningful consultation with opposition parties with regards to the appointment of a new commissioner. Basically, the letter that we received barely a few days ago was take it or leave it. The deadline was Monday, and we are operating under effectively time allocation before the House rises, perhaps as early as tomorrow. Our quarrel is not with you because of that, but I'm sure that you're aware of it. And just in passing, the Liberal House Leader on social media just an hour ago released details of the 4 members of the committee that interviewed you, I guess 3 weeks ago.
Okay.
2 of those members in the Privy Council office, one the Controller General of the Canada Treasury Board, and the other Chief of Staff of the President of the Treasury Board. Because the Prime Minister has had to recuse himself, because other members of the Prime Minister's office have had to recuse themselves, this could be seen as something of an imbalanced committee because, of course, and you mentioned that the Office of Commissioner, the Commissioner's position was created by the House of Commons to serve Parliament, and the House is not represented in the Privy Council office. That again gives us great concern. That aside, it is undeniable that you've had a long and distinguished career in the public service. A couple of black marks associated with your leadership at different times as the leader of any of the more challenging organizations, agencies, and departments in government. But I wonder if you could speak to the specifics of the Auditor General's criticisms regarding your time and those 2 cases in the Integrity Commissioner's office.
So I'll try to be brief, of course, as the chairperson would appreciate, I'm sure. And I will also, you always have to bear in mind that much of what is the underpinning of those 2 reports is confidential. Anything that does not appear in the report is still confidential. So, but with those limitations, essentially under the Public Servants Disclosure Protection Act, the Commissioner is appointed pursuant to that act, and we basically are doing we were doing 2 things. They're still doing 2 things. Joe Friday, my successor, is responsible to receive complaints of wrongdoing, and he's responsible to receive allegations of reprisals for people who have disclosed wrongdoing in the past. There is a provision in the Act that says that if somebody wishes to lodge a complaint of wrongdoing that relates to the operation of the office itself, Public Sector Integrity Office, the Auditor General is responsible to handle these things. In other words, the Auditor General does exactly what the office would be doing vis-à-vis complaints made against other organizations. So it's as a result of 2 distinct complaints that these investigations were launched by the Auditor General under the Public Servants Disclosure Protection Act. When I was appointed there, I say 2011. In fact, I started on December 14th, 2010. A few days after a scathing report, as journalists usually put it, by the Auditor General, in which the former Auditor General, Madame Fraser, basically, I recall precisely what she said. She said she had absolutely no confidence in any policy or procedures that this office had been using in making determinations since its creation. And she was recommending very strongly that the new commissioner essentially review each and every of the 228 files that had been dealt with at that point in time in late 2010. So when I came as interim commissioner from a short period in the private sector, because I did retire in 2009 and came back on December 14, 2010 as interim commissioner, I was faced with a situation. There was a 50% vacancy in the office. We did not actually know how many pending files there were because there was no system whatsoever. So we had to attend to a number of things. We had a profound morale problem as well. So what the Auditor General dealt with in 2012, 2013 in these two complaints was essentially I admit that we dropped these two balls essentially. That we did not, I did not dispute the conclusion. The context was very difficult. My responsibility was that of a leader. I was not personally blamed for something I had done personally. But we had an investigator who basically had serious difficulties at that point in time with hundreds of days of unplanned absences. That was a factor as well, as I say in my response in the report. So it was an unfortunate combination of factors that led to these two reports having come to that conclusion. And we did not do the work as we should have done it, but it was taking place in the middle of a crisis, essentially, involving hundreds of other files as well.
Thank you, Mr. Kent. Next up for 7 minutes, Mr. Cullen.
Thank you, Chair. Thank you, Mr. Dion, for appearing. I share Mr. Kent's frustration with the process that we are engaged in right now. It sounds like you were interviewed a couple of weeks ago.
Yeah, I'd say it will be 3 weeks tomorrow.
3 weeks. We were given notice just late last week from the government, and here you are today with Parliament perhaps closing tomorrow. For such an important, as you would agree, an important position to hire for, this is not, it may be expeditious, but it is not satisfactory to opposition, as you could probably imagine, because a single name on a letter is not consultation by anybody's definition that I know. A question for you. You may have said it in your opening comments, but it's perhaps more of a, no, it's not philosophical, it's legal. Who do you believe that the position of the Ethics Commissioner works for?
Parliament, clearly, okay. House of Commons.
The concern, and you addressed this, I thought you might take the opportunity to address it in your opening comments, is that Mr. Ferguson's audit came in 2014. You'd been the Commissioner for Public Sector Integrity for how long by that point?
The report was tabled on April 15, 2014, so it would have been 3 years after I came to the office.
So the previous Commissioner had some serious problems left in, it's not for your comment, but it's generally understood to left in some disgrace. The department was falling apart. It was, as you say, a scathing previous report from the Auditor General. And I'm quoting from the AG's report. The lack of oversight by PSIC senior managers amounted to gross mismanagement. Do you agree with that finding?
Yes, the expression gross mismanagement is one that's defined in the Act, and his view was that it did constitute gross mismanagement. I don't necessarily agree with his decision that it fits the definition.
Sorry, you don't agree with the assessment from the Auditor General?
Because gross mismanagement is, again, most statutes leave room for interpretations, but it doesn't matter what I think. The Auditor General made the decision that it befit the definition, and I respect that.
But you don't agree with it?
I don't. I still don't.
Okay.
And I didn't at the time, and I told him so.
I'm also quoting, on the basis of the information gathered during this investigation, we concluded that the Commissioner committed wrongdoings as defined by subsections 8A and C of the Public Servants Disclosure Protection Act. Do you agree with that finding?
Yes.
So delaying a decision, ensuring that the PSIC managers understood and followed through on their responsibilities, and not having a process in place to manage declared conflicts of interest. That last part I want to underline a little bit. Not having a process in place to manage declared conflicts of interest. You're applying to be the Conflict of Interest Commissioner.
At the time, the PSIC, the office, did not have a written policy on conflicts of interest.
This is 3 years after you had taken the job?
Correct.
Still no
well,
written...
It's not really 3 years, because the report was tabled in April, but it took them a year to conduct the investigation. So it describes matters that arose a year before that.
Yeah. Okay, but you'd been in the position. I'm just doing the sequence of time to understand. I know AG reports sometimes cast further back, but this AG report and this particular criticism of not having that policy written down on conflict of interest was at least for the 2 years, if not 3 years, but 2 years for certain under your watch.
We did not have a policy.
Okay. You said earlier that
although the general policies, of course, applicable to the public sector were there and did exist.
In earlier response to a question about continuing the investigations, you were not definitive. You said essentially, I don't want to put words in your mouth, but you wanted to look at the evidence that Ms. Dawson had accumulated on the investigations under which Mr. Morneau, the finance minister, and Mr. Trudeau, the prime minister, are currently under right now. Is that
That's right. I think it's my responsibility, if I was appointed as the new commissioner,
yeah,
to review the whole situation.
Ms. Dawson and others have argued that the Act needs to be fixed to not leave it to the discretion of a new appointee coming in, that any, like a court would, as you know, as a jurist, any judge coming in midway through a case would be committed to following through on the case. Yet for this commissioner, you have the discretion. It's in your power, and you're not willing to commit to following through on these investigations. Do you think the Act needs to be fixed to ensure that investigations continue regardless?
I frankly don't have a view at this point in time, because I have not studied in depth, everything that has to do with the Act, and I know that Commissioner Dawson has made several recommendations or amendments.
So no opinion on this continuation.
Nope.
Let me ask you another recommendation Ms. Dawson has made, because you're applying to be her replacement. She has suggested that the conflict of interest to be expanded to include entities, so-called numbered companies, that can receive benefit from a member but don't fall under the Act because they exist as a quote-unquote entity under Canadian law, even though all the benefits might flow to that member. Do you agree with that recommendation?
Based on my knowledge of Mrs. Dawson, I would agree with prima facie with the recommendation, because she's very reflective. So she made that recommendation. It most probably makes sense. However, I would like to see the foundation upon which it was based.
So a conditional yes?
Yes.
Let me ask you a scenario, conflict of interest. I've got 7 minutes to decide whether we should hire you or not. It's a strange scenario. When I'm hiring somebody, I like to give them scenarios to sort of see how they would judge things. The scenario in which the person who's in charge of the hiring process for new ethics commissioner is the same person who is publicly defending the Prime Minister and the Finance Minister who are under an ethics investigation. Do you see any potential conflict of interest in the scenario I just described?
There was a balance in the selection board that I met. You mentioned most of the people who were there. There was a balance. Of course, as the candidate, I'm not responsible for how the selection board is constituted.
When you say balance, the law requires consultation with the other parties. None of the other parties were involved in the selection board process. The person who made that board is the House Leader for the government, is the same person who is publicly defending the Prime Minister and Finance Minister on an ethics investigation. She is also in charge of the process of finding a new ethics commissioner. Would that raise any conflict of interest flags for you?
What I can assure the member, Mr. Chairperson, is that if I am appointed as the ethics commissioner, I feel completely independent. I've had several positions where independence was an important trademark, and I can assure you that in making decisions and in conducting the affairs of the office, I would have complete independence of mind, to the extent that.
So what we're trying to find, it's difficult to determine in such short time, is your conflict of interest compass, your ethical compass on these questions. Assurance that the investigations will continue, that have been ongoing for months, would greatly reassure me, and I think a great number of Canadians. And assurance of that strong voice and independence. Hopefully I can get through another round and ask some questions about that period as Integrity Commissioner. Thank you, Chair.
Thank you, Mr. Cullen. Up for 7 minutes, Mr. Erskine-Smith.
Thanks very much. My first question, you've had a number of different appointments over your long career in public service. Why did you apply for the Ethics Commissioner in particular? Because the nature of the position, of course, is the opportunity to apply for the Ethics Commissioner arises very infrequently. It can be 7 years minimum, and it can be much longer than 7 years. So, and you can see from my CV that I would probably not be available for 15 years from now, when the second Ethics Commissioner might retire. So that's one factor. The subject, I think, the importance of the position. Two, I was talking about institutions that are there to protect Canada's democracy. I have a deep interest in that, basically. Playing a role in each and individual cases I would be dealing with has a lot of appeal to me. That's a second reason, basically. And I've done 11 years at the Department of Justice, where I had to make hundreds of decisions, basically, of a much smaller nature, but of a similar nature, whenever employees and people associated with the Department of Justice were seeking the permission to do something.
Mr. Cullen understood your assurance to be that you wouldn't necessarily be proceeding with the investigations. I understood it differently in your answer to Mr. Kent. I understood you to say you would review every existing case in the office and, on its merits, determine whether you would proceed with the investigation. Is that fair?
That's fair. In fact, and what I'll go a bit further. I will, of course, not make any arbitrary, completely unreasonable decision to discontinue anything for no reason. So
now,
it would be following an analysis. I'll determine if it continues and how it continues.
You've been appointed on previous occasions by Conservative governments. It's especially important that this role be nonpartisan of all things. Is there anything in your past record that would preclude you in any way or affect your ability to hold this government or any future government to account?
In fact, I've been a Northern Council appointee since 1995. I have been appointed 7 times, and it's about half and half, Conservatives, Liberal. I've never had any political activity. I've never held a card of any party, and I jokingly say to people that I don't necessarily vote the same way each time there's an election. So I don't think there's anything impeding my objectivity vis-a-vis political parties.
When you applied, you said you applied online in late summer?
August 18th, yeah.
You had previously applied for any number of positions in the public service or have held positions in the public service. In your experience, are these positions, or in the past, have they been publicly posted in the same way?
No. No, they were not. They were. I was usually approached by somebody to consider, and there was an interview. There were assessments, if you wish, but it was not a public, open process.
Like this one was.
That's right.
And you received a call in mid-November, and you were interviewed. How long was that interview?
About an hour.
And were there any follow-ups to that interview?
There were. There was, of course, I had done psychological testing previously, psychometric testing. So some of the testing had to be redone. I also I redid my English proficiency test. I had been exempted in 1985, but couldn't find the documents. So, so I passed again within 17 minutes. I was pleased with that. But no, there was no other meeting following the selection board. There was no meeting with anyone for the purpose of determining whether my candidacy would be put forward.
You mentioned that you're most proud of the accomplishment in relation to residential schools and what led to the 2006 historic agreement with respect to residential schools. It strikes me as an incredibly important accomplishment. My colleague, Mr. Saini, had asked if you had learned anything, but I'll be more specific. Are there failures along the way? Everyone has failures. Are there failures along the way that you would have learned from? Obviously, residential schools being your most significant achievement, but would you point to other experiences that you would say, I've learned from this and I'll improve going forward?
Yeah, I was involved in program review exercises under the Martin government, under the Chrétien government, and under the Harper government, and I found those exercises very difficult, very imprecise, very dangerous, because we were essentially shooting for a target, and we had little time to make decisions. And sometimes we recommended to government certain things that did not prove to be the best thing with the passage of time, basically. That's one example that strikes me. And I'm not the only one, of course, who has done that in government. Hundreds of us have had to do that.
Sure. My last question, Ms. Dawson has made certain recommendations that this committee has agreed to look at in the new year. And obviously, you've not been fully briefed by Ms. Dawson in any way. You're still the nominee. We had agreed to come back in end of January or early February to discuss her 2013 recommendations, and I would expect to have Ms. Dawson before us. But if you are, in fact, the new commissioner, it would be useful to have you before us as well. Will you have sufficient time over December and January to be briefed and come to your own views on those 2013 recommendations, do you think?
I think I'm a quick study, and the minute I'm appointed, if I am appointed, I'll be in touch with Ms. Dawson. So I'll be ready, yes.
Great. So if we invite you at the end of January, early February, you'll be ready?
Yes.
All right. Thanks very much.
Thank you, Mr. Erskine-Smith. Next up, 5 minutes, Mr. Gord.
Merci beaucoup, monsieur.
Thank you very much, Mr. Chair. Thank you, Mr. Dion, for having appeared before us today so rapidly. I was very impressed by your CV and your journey these past 30 years. Congratulations for what you have done to for our country. In your future, do you think that you will use new communication technologies like Twitter or Facebook, or do you not necessarily see its necessity? I believe that the two media that you have mentioned are rather superficial ones. I don't believe that one can communicate important information through Twitter or Facebook. The office already uses Twitter to communicate information in its most basic form. But it's not a broadcast medium for complicated information. I was thinking more about videos, perhaps, where we can present. Video is very accessible. It's almost free to do so. I would like to do so. Facebook is all about social links. It's not serious. In your presentation, you mentioned 338 MPs and your relation with the current commissioner. There are differences between the two. Could you talk to us about the extra requirements that are valid for public office holders? The code is valid for MPs, all MPs, including ministers and the Prime Minister. The code has obligations that seem to be in the Act, but some provisions of the Act don't apply to only MPs. Some provisions of the Act only apply to ministers and parliamentary secretaries. It would be difficult for me to enumerate them. I brought the table of contents of the Act. Once one is appointed as minister or parliamentary secretary, there are a number of aspects that are regulated that are not regulated under the code. Your question is complex, so we would have to have a comparative text between the two. Yes, the question is complex, so complex that amongst MPs, some people do get confused, which leads to significant problems for the people involved. How will you therefore advise them, or at least check, whether or not people have really understood the Act and their obligations as public office holders? I was talking about a comparative analysis. This has yet to be done, comparing the obligations under the Code and the Act. We could perhaps meet caucuses, we could organize briefing sessions with the Cabinet. If the Privy Council office could organize a session with ministers, we could also meet parliamentary secretaries in particular. We would talk about facts, we would describe, we would raise awareness, we would educate on legal matters one-on-one, but also in a group, because sometimes a discussion can facilitate understanding. We have to be able to participate in a discussion with other participants, small meetings like that, where we study and we talk about this complex and abstract subject. We have concrete examples, but it's a very abstract field. Even when we lose our public office, we still have obligations for a number of years. Is it in months or years? Well, it varies based on the nature of the position you had. It could be until you die. For some, it's 2, 5, or 1 year. For some obligations, there are some people who have to show restraint in their communications for 5 years or until they die. Yes, starting from the date when we left our position, this could hinder their employment in the future. Answer, yes. That is why we have to understand that when one accepts a public office, the consequences it will have for future jobs. It is not always well communicated to new members of staff or new public office holders. When you want to make it a career, that is all well and good, but if you only do it for a couple of years and then it can follow you for 25, 30 years, I think that you should focus yourself on this so that people know what they're getting themselves into. It would be very much appreciated by these people to at least protect them if, well, you know that a political life can last a long time, just as much as it can last a very short time, but the consequences can follow them for a long time. With regards to conflict of interest, I suggest that we have to reread the code, reread the act. It's a rather boring thing to do, but it's important. You cannot simply assimilate it in a couple of minutes. Thank you.
Next up for 5 minutes, Mr. Bayless.
Thank you, Mr. Dion, for being here. I'd like to give you a chance to clear up some of the points that Mr. Kent and Mr. Collins brought up about, I mentioned a black mark on your resume, impeccable resume. It reminded me a little bit of my mom. One time I came home with 99% on my math exam, and she looked at me and said, "Frank, why didn't you finish the job?" I think they're holding you a bit to that level because if I understand correctly, the Auditor General had looked at 2 out of several hundred files. Is that correct?
Yes. 2.
So there was just 2 files. So out of several hundred, you probably had 99% too, I'd guess.
But, you know, the Auditor General basically did not audit anything else. He only reviewed, and he had received a number of complaints.
Yeah.
I don't remember the precise number, 5 or 6, and he decided to investigate
Just
2
those
of them.
Now,
and nobody else complained.
do I understand that those files were existing before you came in? Is that correct?
One of them was, the other one arose after I was appointed.
So one of them was that that one that existed before, you can't impact that anyways. There was a delay that had nothing to do with it. You weren't even there.
No, it was an hybrid file. It started in 2008, as the report says, but it was continuing after 2011 as well.
Yeah, but
So
we can't.
I was accountable for it too, but not for the early portion of it.
Okay. I note that, and I'll quote the Auditor General here, says, given the recent history of PSIC, and you had mentioned that you had to come in and do a lot of work there, said, and the enormous transition within the organization while it was dealing with this file, we did not expect that 100% of the files would have been managed without error. I repeat that. We
Yes.
did not expect the 100% of the files. Can you elaborate on that then?
I was very pleased when I saw that in the draft report because it was an acknowledgement of a very unusual, difficult, generalized situation, and I was pleased to see that the Auditor General was cognizant of the inherent difficulties in managing in that context and would say so in his report. I was very pleased with that.
You had mentioned that when you came in, there was an awful lot of work that needed to be done to get the organization back up to speed.
We basically redid the whole thing. So what I did, I was appointed late December. We reviewed. I hired Deloitte. We did a checklist, complete checklist of things that had to be looked at, and their job was to tell me how many files were defective, how many files did not meet one of the 15 points on the checklist, at least one, some of them more than one. So I was able to reduce the size of the problem. Within 3 months, we knew that we had 71 files that had defects.
71.
And 147, the difference, did not have any defects, according to Deloitte, who did the study. Then step 2 was a decision. I had to make a decision in each and every one of those 71 files as to what would be fair to do for the complainant in light of the defects. Some of them were very defective, some of them had a single little defect. So we crafted a custom-made solution in each of these 71 files. We informed the claimant. We consulted with the claimant, and we made a final decision, and we implemented the final decision in each of those 71 files. I think within about 9 months, the process was over. So we were back to some form of normality. But the staffing problem was a real one. We had 50% vacancy, and we had 50% of those who were there who were demoralized, profoundly demoralized. It's not good to have your organization described as a complete disaster.
So if I understand, you come in, you've got a 50% vacancy rate, you've got 71 files that are not meeting the criteria you've got to get to work on, you've got a demoralized staff, and lo and behold, they say, hey, you know what, these 2 files didn't get done on time. And my personal view is that's not really a black mark. I would look at it as a glass being 99% full. I think you did a fantastic job, and I would like to commend you on that. I also understand that it's not just a Liberal thing, because you've served under many prime ministers that are not Liberal. Is that correct?
I was appointed to public sector integrity by Mr. Harper.
By Prime Minister Harper. You were also appointed by...
At the parole board as well, between 2006 and 2009.
And that was by whom?
It was by the Harper government as well.
Minister Stockwell Day, perhaps?
Yes.
So, okay. And who appointed you to the citizenship and immigration file that you were running?
It was, the Harper government in 2015.
I find it interesting that Mr. Kent would find flaw with one or two little things that you didn't get done in an amazing set, and yet time and time again, the Conservative government...
I'd like to correct something. So, Indian Residential School, 2003 was Martin government. 2006 to 2009 was the parole board, the Harper government. 2010 to 2014 was the Public Sector Integrity Office, and that was by the Harper government as well. And the IRB was also the Harper government.
And I know I'm running out of time, but I think it's a very important point to underline in your candidacy is that both major parties have seen fit to put you in major leadership roles time and again, not just once.
That's correct. Yeah.
That's correct. Thank you.
Thank you, Mr. Bayless. Next up for 5 minutes, Mr. Kent.
Thank you very much, Chair, and thank you again. You mentioned a few moments ago in conversation with my colleague social media. Have you participated on Facebook or Twitter in the past?
Yes, I have participated, as you put it. Facebook, not very much. Twitter, more, for a few years. Yeah.
Now, I'm given to understand that you've pulled down your Twitter account or put it into limbo. I'm just wondering, is that because of prudence, given the impending...
If I'm appointed, it's clear to me that the nature of this position makes it absolutely impossible for me to continue to express publicly views about virtually anything. So I did essentially, I don't know what the technical word is, but I did close my account many days ago, because if I am appointed, I will not go on Twitter whatsoever, except as so far as the institutional account is concerned. Yeah.
The penalties for violation of the Conflict of Interest Act are very modest, and Commissioner Dawson has made it clear that...
Maybe turn down, sorry, Chair, there's feedback. Maybe turn down your...
It's not... It's nowhere near.
Yeah, I don't know why it's getting feedback.
It's nowhere... Yeah, it's not me.
It's not me either.
Do you want to maybe switch microphones and see if that helps?
But, there. Yeah, it's not me.
Try unplugging your earpiece and see if that helps. It's coming from somewhere, some line.
No. Anyway, coming back, Commissioner Dawson has said that, in effect, that naming and shaming is really the only penalty. The finance minister, for example, when he was found in violation of the disclosure of holdings, was fined barely $200. I wonder if you have any thoughts on perhaps stiffening the penalties for violations, serious and minor.
As a citizen, you know, I've been a news buff all my life, so I'm therefore aware of, and I have followed the work of Mary Dawson ever since she was appointed. As a citizen, I do find those penalties. It's a little bit like the NHL when a player gets fined $500 and you know that he earns $5.8 million a year. It may not be sufficient to create the disincentive that we're trying to create.
Now, one final question. Commissioner Dawson has recommended, or called, actually, for the merger of her office and the office of the Commissioner of Lobbying. The former commissioner and the newly nominated commissioner both disagree with that, saying that they are two sides of some of the same ethical issues, but that the offices should remain separate. I wonder again your thoughts on whether or perhaps there should be a merger or closer cooperation and integration at some level.
One thing that's clear in my path, my career in the public sector, is that I am not territorial. Another thing that's clear is I do abide by the law, however, as it exists. So I have an open mind, and if I'm appointed, I will, of course, once we have been both briefed, if Ms. Bélanger is appointed, we will meet, we will discuss the operations of each of our offices, and if we come to the conclusion that it would be more effective or more attuned to serve the public office holders and Canadians at large, I can assure you that I have an open mind vis-à-vis reorganization and restructuring, because structures should serve the purpose as opposed to the opposite. Structures are there to serve a purpose. And if they prove to be inadequate, then they should be changed. And of course, it would be for the government or the House of Commons and the Senate to decide whether to change those structures.
2 minute and a half.
Certainly. Again, Commissioner Dawson some years ago submitted to this committee and to the government a list of recommendations for changes to the Conflict of Interest Act, the operation of the office, and so forth. Again, would you commit to, at some point, not early in your term, but at some midpoint, offering a consideration or updating of recommendations that had been made by Commissioner Dawson in the past, and whether or not the government should consider implementing those changes, those recommendations now?
I see this as part and parcel of the role of the commissioner. I did that at PSIC. We basically started to work on a series of proposals shortly after I was appointed. You have to have enough experience to, of course, have a foundation on which to base it. I think it's part and parcel, and I've already answered your colleague earlier, Mr. Chair. I did indicate that I would be, I will study what Mary Dawson has recommended back in 2013, and it's part of my role, and I will be pleased to present recommendations if and when I'm in a position to do so.
Thank you, Mr. Kent. Next up, Mr. Picard for 5 minutes, but we have one more question. I'm going to let the time go a little longer than 4:30, so we've had some delays, so continue, Mr. Picard.
Merci. Thank you. Welcome, Mr. Dion. I'm pleased to meet you for the first time. I understood from a comment you made to Mr. Kent, you talked about the evaluation of a fine that is insignificant and not commensurate to the monies involved, $500 for 500 million, for example. I would like to know what culture you wish to implement and that you seek to implement in this office. What would be best practices for you? Would you look for the true understanding of facts? Well, I'm a big fan of dissuading people and deterrence. Our work is preventative. Inasmuch as we try to raise awareness, we try to educate. Fundamentally, people are honest. When a complaint is made, when we investigate, and when we conclude that an offence has occurred, the punishment needs to be commensurate, so that like in all system that seeks to manage people's behavior, people need to understand what the consequences are if one were to flout the law. A number of MPs have the following reaction. The day we're elected, we no longer have a life, because the people we used to know are now people who could potentially create conflict of interest based on professional relations that they may have. Is that just simply a fact of life? When you're elected as an MP, if you're a minister or even more, isn't that just part and parcel of the compromise? I think that Canada has created such a system. The first ethics code comes from 1973. It simplified obligations, but obligations become stricter and stricter. Were I to be MP, which I have never been, I would have kept all of this in mind. This is a regulation for our behavior that manages us 24/7, and we always must keep it in mind. There are some things that are not natural. It's not like the criminal code. You do not have to read all of the criminal code to avoid committing a crime. Usually, we have an intuition of what is criminal and what is not. In this statute, there is not necessarily intuitive rules. And so that leaves room for interpretation. Answer, yes, a lot of interpretation. You were Commissioner for Public Service Integrity. I believe that the integrity factor could meet the integrity factor of this position. What are the commonalities that you could base yourself on based on these two positions in the short and medium term? What is your vision for that which you will be able to progress based on the information that you have on the public sector? A clear commonality is accessibility, the necessity of being very, very accessible, so that people who can file a complaint should know that they can file a complaint. We did this at public sector integrity so that people would understand the parameters of what we regulate and what we do. This is something that I would seek to do here. That is our way of thinking. Accessibility, allowing the law to flourish, allowing the spirit of the Act to come into play. Commissioner Dawson, when she appeared here in 2014, said that she was surprised that only between a quarter and a third of case files that came from complaints. The rest were proactive measures undertaken by herself. I believe that perhaps there are possibilities. Complaints are a tool for self-regulation. If the office is accessible, it is another way to make sure that public office holders and MPs are honest, because they're always at risk of being complained against. So you want a denouncement mechanism. Yes, I think that the current statutes encourage this already. It depends on the spirit of each act. If an MP can complain, well, very few MPs do complain currently.
Picard.
Thank you.
Mr. Cullen for 3 minutes, and Mr. Kent for 30 seconds.
I'll take you back to an email you sent as Integrity Commissioner on February 2nd to Mr. Waters, who is one of the top officials in the government at the Privy Council. And I'm quoting an email that you sent to him. There is one issue that your office is currently not privy to and that the clerk must be briefed on. A former senior official at the office has retained legal counsel in order to pursue a claim for constructive dismissal. I will be pleased to provide details to a PCO officer to ensure that Wayne, that's Mr. Waters, is not blindsided. Do you regret that email at all?
I don't recall. I frankly do not remember. I'm not saying I did not write the email, but I don't recall that the subject matter was.
The email came out through documents. It's in the Globe and Mail.
What year was it?
This is soon after you took office. This is after Madame Ouimet left. The Liberal commissioner, the Liberal chair of the committee was quite scathing about this interaction with a senior official. It was a heads up. It was an email from you to him saying, I'll prepare to brief you, so that a PCO officer to assure that Wayne is not blindsided.
I have no recollection, I'm sorry.
You have no recollection of that?
Whatsoever.
Okay.
No, I must have written hundreds of thousands of emails.
Well, I understand, but I guess, do you see my concern? That as an integrity commissioner, if you're giving somebody who might be falling under investigation a heads up so that they're not blindsided, would fall completely outside of your purview to do.
The wording of the email that you just read would indicate that Mr. Waters was not the subject. It was somebody else in the system who was the subject.
To make sure that Mr. Waters, that Wayne is not blindsided.
But it was not about Wayne. It was about somebody else that reports to Wayne.
Oh, so you're tipping off Wayne to make sure that he knew that somebody in his staff was about to maybe fall under.
To give the clerk a chance to organize and respond, essentially.
Right. So,
but I don't recall who it was or what it was.
Madam Fraser pointed out, as the Auditor General, that there were 228 cases that were not properly investigated. Of those, how many did you decide to investigate in the end?
Okay, Mr. Calden, I'll be pleased to provide the answer to the committee, but I frankly do not remember how many we investigated.
Ballpark? Like More than 100? Less than 50?
I said in, I think as part of my introductory remarks, that during my term at ETHI, I oversaw 100 investigations. Some of them were we met, and some of them arose after I was appointed.
So you said earlier in testimony that people don't wake up with an intent to break the law. You're trusting. What's intent?
I used to work in the correctional service, so there may be some exceptions.
But my question is, what's intent got to do with it? I may not intend to speed, but if I speed, I'm breaking the law. The Prime Minister might not have intended to get on a private helicopter, but he did.
No, all I was saying is that education is important because people want to do well. And if they do realize what the expectations are, it's less likely that they will inadvertently break the law. Inadvertently break the law. Try to avoid that.
I'm going to quote from the AG report again on your office. The Public Sector Integrity Commissioner decided not to investigate the complainant's reprisal and decided to close it on 2nd of April 2013. As a result of internal delays, lack of management oversight, and related failures, the complainant had to wait over 18 months and concluded with, in the complainant's statements, that trust was lost in the relation to the PCISC's process. Do you agree with that finding from the Auditor General, that trust was lost?
Yes, it was indeed. The complainant had lost trust.
You understand, like, one of the concerns, I understand your difficult position in not wanting to fully commit to continuing the investigations, which I would, you read the papers too, into the Prime Minister and the Finance Minister of Canada. Like, you don't get higher than that. That in your previous role, there were challenges in continuing certain investigations. That we have this process that you applied in the middle of August, you had a 1-hour interview in November, the committee gets 7 minutes to hire you for a 7-year position. I guess what it's hard for me to determine, because it's not possible in this interaction, is that are you tough, are you fair, but are you a dog with a bone? Would you describe yourself as somebody who pursues it to the end to make sure that it happens? Because that's the confidence that we need.
We're at time, Mr. Collins, but I'll let Mr. Dion answer.
Very brief final answer. I tabled 10 reports while I was at Public Sector Integrity. Some of them were very tough, and I did not give up, and we went to court in some instances to retain the ability to go forward with the investigation and the tabling of the report, and I'd be pleased to say more. Some of these reports were hard fought, and I believe in abiding with the law is very important, and the resources should be used on those cases where it really matters. That's essentially what I was saying earlier as well. So, but you know, in the 2 cases that the Auditor General investigated were not, I can assure you, in the global scheme of things, very important matters to start with, unlike the matters that you have been talking about.
Thank you, Mr. Cullen. Mr. Kent.
Just a very short question, Mr. Dion. And again, recognizing that you have a very, just for Mr. Bayless's clarification, we recognize you've had a very distinguished public service career, but in a couple of the appointments that you accepted and where you were the authority, the individual responsible, capacity seems to be fairly directly connected to the criticisms that were assigned to you as the authority of those organizations or agencies. And I'm wondering, and because, again, of the nature of the Ethics Commissioner's office, we don't know whether Commissioner Dawson actually has the capacity to maintain and follow as many investigations as she has had recently. I'm just wondering if you would convey fairly directly, and I'm not sure of the reporting command to the House of Commons. The House of Commons, of course, created the office and the Commissioner's location, whether you would convey the information of the need to expand capacity for the office to operate in a timely fashion.
Mr. Chair, under the Act, one of the very, very significant thing is that the Commissioner forwards the budgetary needs to the Speaker, and the Speaker essentially asks the President of the Treasury Board to make those allocations. So there is a right in the statute, there is a power to essentially ask what you need in order to meet the needs of the moment, and very little discretion not to give it to you. It has to be done in a responsible way. And throughout my career, I have been involved in numerous Treasury Board submissions, so I know something about calculations and preparation of submissions.
We didn't get one this year.
Okay.
Thank you, Mr. Kent. Now we have a motion from Mr. Erskine-Smith. Go ahead.
Thank you. The point of order, one of the principles in our House is the independence of the committees to operate fully and perform our functions. One of the functions this committee has is to review certain selections for certain officers of Parliament. This being one of them, we also had lobbying as well. I'm looking through the timeline and the sequence of events with the process, which I think I've made myself fully clear my level of dissatisfaction that after 3 extensions, 18 months of extension for the previous officer, in this case of ethics, that we had a 1-hour interview and apparently 1-hour interview. I'll get to the point of order here that the government introduced. We had to call these emergency meetings to facilitate this process as the session is winding up before the holidays. The government introduced a motion to vote on the reference of Mr. Dion in this case, almost simultaneous to whether this committee was even going to meet and have this brief 1-hour time with him. We now have, under Mr. Erskine Smith's, the required, I'm sure his authorship is all over this and his own insights into the wording. And
I guess I would like you to get your point of order.
My point of order is this, that the committee's ability to do our work that we've been asked and tasked to from the House of Commons is infringed by the government's House Leader, who introduced a motion to have a vote on Mr. Dion prior to even the committee being assured that we would have this meeting in the first place. We invited Ms. Chagger to appear. Liberals, with one notable abstention, disagreed with that to explain how we got to this process in this state. And I would argue that it puts not only a cloud over this committee, but not to no fault of the applicants, the nominees, a cloud over the officers of Parliament who are working, as Mr. Dion rightly said, behalf of Parliament. It's very frustrating to allow this vote now, as I assume what Mr. Erskine Smith will now move, a vote on the motion to proceed to the House, when it was the House Leader's choice to, what I would argue, is subvert the effort of the committee to have a proper hearing. If we had not been able to meet today, Chair, the House would have a vote tomorrow afternoon on Mr. Dion. Is that true? So through you, to the House.
Mr. Cullen.
What's that?
I would still want you to get to your point of order. It's still debate up to this point, so I still haven't heard a valid point of order other than you've made some points, but point of order is, I don't believe, one of them.
Well, noted through this, and again, I said this to our previous candidate, to participate and validate this process in any direction for us is non-tenable, as it was for Mr. Erskine Smith over the request of the House Leader to appear before us. So, as I said to Mr. Dion off record before this meeting started, I say to him now on record, nothing personal, but it's very frustrating and I think regrettable that we're at this stage as the committee charged with this to do this important work to hire somebody for 7 years to hold us all to account.
Thank you, Mr. Cullen. We'll go on to the motion.
Thanks very much, Chair. So the fact is we did meet, and having heard the answers from Mr. Dion, I move that the committee report the following to the House, that we've considered the certificate of nomination of Mario Dion, nominee for the position of Conflict of Interest and Ethics Commissioner, referred on Monday, December 11, 2017, pursuant to Standing Order 111.1 sub 1, and that we and that he be confirmed by the House of Commons as Conflict of Interest and Ethics Commissioner.
Okay, so it's before committee. Any further debate? Mr. Kent.
Thank you, Chair. And let me say the official opposition agrees with the NDP's rejection of a completely unacceptable process and the lack of meaningful consultation in this process. But at the same time, we believe it is most important that we ensure continuity in the operation of the Office of the Ethics Commissioner. So we will, and again, separating our great concern with the government's process, we believe that we should hold a vote and that in fact Mr. Dion should be recommended for a vote in the House of Commons for nomination, for appointment.
No, Mr. Cullen.
Thank you. I hear Mr. Kent's intervention in terms of continuity. That was one of our concerns that we raised in the media weeks and weeks ago, knowing that Ms. Dawson's term was coming due January 8th, that this committee would not sit until the end of January. It was in fact us that first proposed the idea of the committee coming back together to find out what's going on and are we going to have an ethics commissioner at all. That's simply a lack of planning on the government's part. If they conducted the interviews, as Mr. Dion has told us, testified today in mid-August, took the applications in mid-August, I don't want to get the record wrong, interviewed three weeks ago, I think is what we determined, and that at the very last moments of Parliament sitting, with the fear of having no ethics commissioner at all, this is the path that the government has chosen. My grandmother used to say, a lack of planning on your part does not create a crisis on mine. And I'm, with 18 months notice, 2 years plus in government, the government knew this day was coming and chose the 11th hour in which to put this through. And I don't know about Mr. Dion or my colleagues, but I have more rigor hiring my legislative assistants and my staff assistants in the riding than an hour interview from a list of one. This is such an incredibly important position. The officers of Parliament have great sway, as Mr. Dion and others have said, that this is the process, and the Prime Minister still today chose to call this meaningful consultation. I don't understand how my Liberal colleagues can see it as that. They would certainly not accept it if they were sitting on this side of the table, for certain. And in the past, when we've hired Sergeant-at-Arms and other officers of Parliament, other people that work for all of us, we've had committees that were multi-party. And it worked, because every party had input into the candidates, shortlisted, and then put that forward to the Prime Minister for a nominee of a candidate. That's still giving the Prime Minister an enormous amount of discretion to choose from a list of 3 or 4. But importantly, with all party support throughout the process. So that, as Mr. Dion and others have pointed out, that these officers remain beyond any concern of partisanship or influence or any of those things, as was rightly questioned by one of my Liberal colleagues today. But to push the opposition completely out of the process, to send what I think is an insulting letter saying, here's the one name, you've been consulted, congratulations, have a 1-hour meeting, and then a vote tomorrow in the House of Commons and call that due process. My Liberal colleagues know it's not. And it's unfortunate, because it creates this tension that I would argue is totally unnecessary. We want to get this right. We want the best people in the position, because they run our elections, they guide us on ethics and lobbying and all these important things. And to create an insulting process is really unfortunate, and certainly not the expectation or the promise made by the Liberal Prime Minister when he was running as a candidate for this office. So it's unfortunate. I'll be abstaining again, and it's, again, as I said to Mr. Dion, no reflection on his candidacy, but just a totally disgraceful process that got us to this place.
Thank you, Mr. Cullen. Any further debate on the motion? Okay, we'll vote on the motion. All in favor of the motion? All opposed? All opposed? Motion carries. Thank you, Mr. Dion, and wish everybody at committee a Merry Christmas. Thank you. Meeting's adjourned.